So the next topic is constitutional amendment. Okay, very simple topic. So one more, it is a function of parliament. Okay, it's a function of parliament. So only the Parliament of India can amend the constitution. So we have discussed in the introduction class that our constitution is flexible. When I say flexible, it means that provisions of the constitution can be changed depending upon the requirements of the current context. So if there is anything that needs to be added, if there is anything that needs to be removed, if anything has to be changed, better clarity is required, etc., we can change the constitution. That is known as constitutional amendment. So you have to remember this thing. Article 368 deals with the powers of the parliament to amend the constitution and its procedure. So Article 368 deals with the powers of the parliament. Okay, powers of the parliament as well as the procedure. How to pass or how to bring about the amendment of the constitution. It is mentioned in part 20 of the Indian Constitution. Okay, so who can do it? It is the parliament. Where can it be initiated? In the parliament. Which house can introduce? So again, just to make you aware that all constitutional amendment can happen by introduction of a bill. So that bill is known as Constitutional Amendment Bill. So all the amendments begin with a constitutional amendment bill. It's a proposal to amend the constitution. So we have to remember now, or we have to understand who can introduce this bill, that is Constitutional Amendment Bill, and where can it be introduced. So who can introduce? All members of parliament. So all the MPs are having the power to introduce a constitutional amendment bill. When I say all members of parliament, they can be either from Lok Sabha or from Rajya Sabha. They can be ministers, they can be non-ministers, that is private member bill or a public bill. So constitutional amendment can be introduced by the government also, it can be introduced by the opposition also. Please remember that. Also, it can be introduced by nominated members as well as elected members. See, I'm just stressing on this because sometimes they can ask question and you might overthink and make mistakes. So all members, irrespective of whether they're elected or not, nominated also, both the houses, either of the government or opposition, all MPs, where in either, please remember this, either of the house, that is either in Lok Sabha or Rajya Sabha. Does it require president's recommendation? No. There is no need for president's recommendation to introduce a constitutional amendment bill. Is that okay? So that is what is some facts that you have to remember. Okay. Now, before we go into a little bit, before we going into the procedure, you should understand the constitution. Okay, provisions can be divided into following. I have written it there, but it can be divided into following. Okay, so those provisions dealing with federal issues, those matters which are dealing with federal issues. Okay, those dealing with non-federal issues, those dealing with basic structure, and those dealing with ordinary administrative matters. Okay, something like this. I mean, it's not there in the constitution as such, all these, but for our better understanding. So some parts of the constitution deals with federal issue, like state matters, state subjects, okay, president, judiciary, okay, etc. So these are all federal issues. Okay, and then we have non-federal issues, okay, like the fundamental rights, DPSP, Okay, majority of them deals with non-federal issues. Then we have basic structure. So please remember, there is no definition of basic structure that is given in our constitution. This idea of basic structure was introduced by the Supreme Court. Okay, it was introduced by the Supreme Court in a case known as Kesavananda Bharati case. In this case, the Supreme Court invented the concept of basic structure. It did not define it as such, but the basic structure, according to the Supreme Court, is so important that it cannot be amended. Okay, basic structure cannot be amended. It is so important that it cannot be amended. So in various judgments, Supreme Court has come up with a list of these basic structure. Like for example, sovereignty, okay, of the country, secular character, federalism, okay, then independence of judiciary, okay, judicial review. Like this, it has come up with several, a list of provisions which can be categorized as basic features of the Constitution. And they are called as the basic structure. And according to the Supreme Court, these cannot be amended. And then the third one is the ordinary administrative matters, which is necessary to run the country. Okay, say for example, formation of state. The division of state is for administrative convenience. Correct? We have discussed this when we did part 1 of the Indian Constitution. Okay, formation of state. Matters dealing with 5th and 6th schedule, that is tribal administration. Okay, those dealing with use of official language, citizenship, elections. So there are many provisions in the Constitution that is responsible for ordinary administrative, or which is required for ordinary administrative requirements. Okay, so now I hope you have been able to appreciate this. Again, I will recap. So there are some provisions in the Constitution dealing with federal issues, some provisions dealing with non-federal issues, some provisions which are called as basic structure, and some which are required for ordinary administrative matters of the country. So there are all these four things have different approach. So Constitution, before we go into the procedure, the Constitution can be amended under Article 368, which requires special majority. What is this special majority? 2/3, more than 2/3 present and voting, plus absolute majority. So this is the kind of special majority that is required. More than 2/3 present and voting and absolute majority is required, okay, to pass a constitutional amendment bill. Anyways, now let me again come back to our discussion over here. Why did I have to do this? So any matter dealing with federal issue, it requires special majority in the parliament, plus approval by more than 50% of the states. Okay, more than 50% of the states should approve these provisions. Okay, so federal matters in our Constitution, like as I told you, the state subjects and all that, if it has to be changed, it can be changed only with the approval of the parliament plus approval. So we have 28 states. So at least 15 of the states should approve it. Approval is by simple majority. That is more than 50% of present and voting. I hope all of you are able to appreciate this. I'll give you an example. The GST bill, which introduced the GST tax. Okay, so this GST bill, a constitutional amendment was required because it allowed the center to tax on state subject and state to tax on central subject. So effectively, it was federal issue, meaning it was going to change. This GST bill, 101 Constitutional Amendment Act, was going to change the federal division of power between center and state. Okay, so 101 Constitutional Amendment Act, which introduced this GST bill, changed the federal division of power in the constitution, and hence it required both the parliament and the state. It was introduced in the parliament and then it was approved by the state. Please remember, the bill can be introduced only in the parliament, but in case if it is federal issues, it also requires the state's approval, because the constitution is same. Indian constitution is applicable to even the state. So when it is dealing with federal issues, it requires the approval of the states. Then those which are dealing with non-federal issues, so they can be passed by the parliament without the requirement of states. So non-federal issues. Now let's say, for example, if fundamental right has to be changed. So this is done by the parliament. Again, the procedure, the majority is special majority. So special majority in the parliament alone. See, for example, 104 Constitutional Amendment Act, which extended the reservation for SC and ST, right? So reservation in the parliament and state legislature was extended for 10 years under the 104th Constitutional Amendment. So this was done by the parliament without involving the state. Why? Because it does not deal with federal matters. Similarly, 103rd Constitutional Amendment Act, which added, you remember, 15 clause 6 and 16 clause 6, which provided for reservation for economically weaker section. So it made changes to fundamental right. This was done again only by the involvement of the parliament. So what did you understand? So Article 368 has two ways to amend the constitution. One, where only the parliament is involved. The other one, where parliament plus the state is involved. So the second one, parliament plus state, happens only when there is the federal issues that are involved. Okay. Then the third one is with respect to, what did we write? Third one, yeah, basic structure. Third one is the basic structure. So the basic structure cannot be amended. So it is a rigid aspect of the constitution. So those cannot be amended. Even if the parliament amends that provision, then it shall be held as invalid. The Supreme Court has said that any amendment which removes the basic structure of the Indian Constitution, okay, is invalid, unconstitutional. And lastly, outside Article 368, to amend those matters dealing with administrative things, that's I told you, citizenship or formation of new state, etc. If you recollect what we have done in class, example, formation of new state, correct? Though it is amending the constitution, it is done outside the scope of Article 368 as mentioned in Article 4. Remember, now you should be able to relate all these. Article 4 provides power to the parliament to make changes to the provisions of the state without amending the constitution under Article 368. This is an example. Okay, so now if I have to conclude all these four things, so there are some provisions in the constitution which can be amended by simple majority, that these all can be amended through simple majority because they can be amended outside the Article 368. So some can be amended through simple majority, some can be amended through special majority, some can be amended through special majority in the parliament plus involvement of the state, and some cannot be amended at all. So that is why our constitution is called as flexible as well as rigid. So because it can be amended through simple majority, it is flexible. Because certain provision cannot be amended, it is called as rigid. So our constitution is flexible as well as rigid. So this is what you need to understand from the constitutional amendment point of view. Is that okay, guys? I hope you understood. Now let's talk about the procedure. Okay, talk about the procedure, very simple. So first, for any amendment of the constitution, a bill has to be introduced. Okay, the bill can be introduced in Lok Sabha or Rajya Sabha. It can be introduced by any member of parliament. It can be introduced in any member of parliament. The stages are same as that of an ordinary bill in the sense that, okay, so first the bill is tabled, then it is there goes to the second stage, that is the second reading. In the second reading, general discussion is done. It is sent to the committee stage, right? All that which we have discussed recently, right? It is sent to the committee stage. It is even distributed among the public for their opinion. Then the opinion and all is collected, and each of the clauses are put to vote one by one. So members can introduce motions to change the bill. All right. And finally, the bill is put to vote. Is that okay? So discussion, I'll just write it like this: discussion plus voting. I won't go into all that first reading, second reading and all that. So anyways, that we have already completed. So after the discussion of the bill, it is put to vote. What kind of majority? So in the parliament, it requires special majority. It requires special majority. That is more than 2/3 present and voting plus absolute majority. I have explained all this, okay, what it is and all. So just refer to that. So once the special majority, it is passed in one house, it goes to the second house. It goes to the second house. In the second house also, the same thing happens. Okay, in the second house also, it has to be passed. Has to be passed. Else it will come to an end. So there is no provision. There is no provision for joint sitting. Please remember this. There is no provision for joint sitting. So in case if there is a deadlock, what we have discussed, in case if there is a deadlock, then there is no provision for joint sitting. That means both Lok Sabha and Rajya Sabha has to approve the constitutional amendment. See, that's why it is so significant. You cannot keep changing the constitution. Both Lok Sabha and Rajya Sabha is required. That is why only the constitution has been amended only 105 times since 1950. Only 105 times it has been amended because it is difficult. Here both the houses are required. Both has to approve it. See, for example, the GST, okay, was proposed almost 7 years before it was passed. So almost for 7-8 years, the bill, GST constitutional amendment bill, was pending because the government did not enjoy majority in both the houses together simultaneously. So anyways, what I'm trying to reiterate here is that both the houses are required as equal power for the passage. So there is no provision for joint sitting when there is a deadlock. So when there is a deadlock, I told you deadlock when we discussed ordinary bill. When there is a deadlock, the bill comes to an end. Bill comes to an end. When is a deadlock? When the first house passes the bill and the second house rejects it. When the bill is passed by the first house, amended by the second house, and sent to the first house, and the first house rejects the amendments made to that bill, then also it is a deadlock. Or when the bill is not acted upon by the second house for a period of 6 months. In all these three cases, we say there is a deadlock. So when there is a deadlock, the bill comes to an end. Unlike ordinary bill where there is provision for joint sitting, there is no such provision over here. Then the fourth stage is the bill sent to the president. Once the bill is sent to the president has only one option to give his assent. Please remember this constitutional amendment bill. The president has only one option to give his assent. He cannot send it back. He cannot reject it. He has to give his assent. Is that okay? So that is one. And now one more stage that can happen over here before going to the president is if it is dealing with federal issue. If it is dealing with federal issue, then it is sent to the states, the 28 states, of which 50%, if they pass, more than 50% pass it. Now the GST bill was actually sent to the states. So more than 50% of the states passed it. If they pass it, then it will go to the president. If the states reject it, if they fail, what we call it as a ratification, if the states do not ratify it, that means more than 50% of the states do not ratify it. Let's say 8 have ratified it, 20 have rejected it. In such case, also the bill will come to an end. Nothing can happen. So in case if they also pass it, it will go to the president and then. So this is to do with only federal issue, not on other matters. Only those provisions in the constitution dealing with federal issues, okay, they have to be sent to the states. Now, what are the provisions of federal issues? Okay, one is with respect to the President of India. Okay, provisions relating to the President of India. Then, powers of center and state, the central subject, state subject. Any change that has to be done, okay, is a federal issue. Then, Supreme Court and High Court. Any changes that has to be done to Supreme Court and High Court, because we have an integrated judicial system for both center and state, right? So Supreme Court and High Court, anything that has to be changed. Okay. So powers of the center and state is mentioned in the 7th schedule of the Indian Constitution. So powers, executive power, legislative powers of the center and state. Then representation of states in parliament. So any changes to that also. So you remember that we had to amend the constitution to put a cap on 1971 census. So that also was done through a constitutional amendment, right? So all that can be done only through constitutional amendment requiring the approval of the state. So representation of states in the parliament. And finally, Article 368 itself, that is the amending the constitution in itself, also requires, if any change has to be done, the procedure and all that, it can be done only with the approval of the states. Is that okay? So these 5 things are called as federal issues and it requires the states to ratify them.